the Supreme Court just handed down a ruling so sweeping, so absolute, so unanimously decisive that state capitals from Sacramento to Albany are in full-scale legal meltdown right now. And most of what you're hearing about it is either incomplete, dishonest, or deliberately designed to make you panic without understanding what actually happened. This isn't a partisan story. This isn't left versus right. This is the Supreme Court of the United States. All 9 justices coming together in a 9-0 decision that didn't chip away at a gun law, didn't create a minor exception, didn't send something back to a lower court for review. It dismantled the entire legal architecture that 19 states have used to restrict firearms for over a century in a single ruling, 9-0. And if you still don't know what the Supreme Court just did to gun law in America, if you still think this is just another headline that fades by Friday, then you need to stay with me right now, because this changes the ground beneath your feet whether you own a gun or not. If this kind of accountability journalism matters to you, the kind that cuts through spin and tells you what is actually happening to your rights and your country, then subscribe right now. Hit the bell. Because the story is moving faster than any algorithm can track, and I am going to be here every single day pulling apart what these rulings mean for real people living real lives. Here's where we were before this ruling dropped. 2 years ago, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin, and that decision was supposed to settle the question of whether Americans had the right to carry firearms outside their homes. The court said yes. It established a new legal test, one grounded in the historical tradition of the United States at the time of the founding, and it sent a clear message to the states. You cannot restrict the right to carry in ways that have no historical precedent. That should have been a clear signal, but what happened instead was a slow-motion legal catastrophe. Lower courts didn't know how to apply the new test. Some demanded a near-perfect historical twin for every modern gun law, a law from 1791 that looked almost identical to whatever regulation the state was defending today. Others applied it loosely. States like New York and California didn't retreat. They advanced. They rewrote their laws to be even more restrictive, dressed up in slightly different legal language, and dared the courts to strike them down again. For 2 years, gun owners and civil liberties lawyers were caught in a whiplash of contradictory rulings. A law was valid on Monday and gone on Thursday. States were openly defiant. The legal system looked like a demolition derby with no referee. Then this ruling came down, and it brought a referee, 9 of them, unanimous, with a gavel the size of a constitutional wrecking ball. What makes this ruling so seismic is not just the outcome. It's the legal standard it applied for. For the first time in living memory, the Supreme Court applied strict scrutiny to the Second Amendment. If you've never heard that term, understand this. Strict scrutiny is the highest, most demanding standard in all of American constitutional law. It is the standard reserved for your most fundamental rights: freedom of speech, freedom of religion, the right to vote. When a government law faces strict scrutiny, it doesn't just need a decent justification. It needs to be proven essential to a compelling government interest and must be the absolute least restrictive means of achieving that goal. In plain language, if there is any other way to accomplish what the government wants without infringing on your right, the law fails. It's dead. For decades, lower courts have been treating the Second Amendment like a second-class right, applying something called intermediate scrutiny, a much softer standard that basically said if the government had a halfway reasonable argument, the law could stand. That world is gone. The court just elevated the right to bear arms to the same constitutional tier as the right to speak freely and the right to cast a vote. And that elevation is not a technicality. It is an earthquake. Once you understand what strict scrutiny means, the 5 categories of gun control law that just collapsed stop being surprising. They become inevitable. The first to fall was the May issue permitting system, and good riddance to it. In states like New York and New Jersey, the law gave local law enforcement or judges nearly unlimited discretion over who received a concealed carry permit. You could be a law-abiding citizen, pass every background check, complete every required course, and submit every form with perfect accuracy. And still, a police chief could write a letter stating that you hadn't demonstrated a specific need or proper cause to defend yourself, and your application was denied. Think about what that actually means. It means a government official got to decide, based on his own judgment and with virtually no accountability, whether your constitutional right applied to you personally. It was a gatekeeper system dressed up as law. The Supreme Court had already signaled the death of this system in Bruin 2 years ago, but many states simply ignored the signal or invented procedural workarounds to preserve the same gatekeeping function under different language. This 9-0 ruling is the sledgehammer that finishes the job. Subjective discretion is constitutionally dead. If you are not a prohibited person, the state cannot manufacture a reason to keep you disarmed. The second pillar to fall was mandatory training requirements. And here is where honest nuance matters, because the court was careful. Nobody on this court said training is bad. The justices explicitly acknowledged that training is valuable and beneficial. What the court said is that the government cannot weaponize training requirements as a financial and logistical barrier to a constitutional right. If a state requires you to complete a $500 course offered twice a year in a city 3 hours from your home, and you cannot obtain a carry permit without completing that specific course, then the state has effectively imposed a poll tax on the Second Amendment. The comparison is not accidental. We fought a constitutional battle in this country over poll taxes on voting rights precisely because we understood that requiring people to pay money to exercise a fundamental right is not regulation, it is suppression. The same principle now applies to the right to bear arms, and the states that built elaborate training prerequisites specifically to price low-income citizens out of gun ownership just had their playbook burned to ash. The third pillar, waiting periods, fell next, and this one is going to generate the most emotional pushback. The cooling-off period was always an emotionally appealing idea. Give an angry person a few days to calm down before they can pick up a firearm. It makes intuitive sense in the same way that a lot of things make intuitive sense right up until you hold them to a constitutional standard. The court ruled 9-0 that delaying the delivery of a lawfully purchased firearm imposes a burden on the law-abiding citizen that the government simply cannot justify under the new historical standard. There was no widespread tradition of waiting periods in 1791. The law cannot stand. Excessive application fees fell in the same sweep, with the court making clear that permit costs must be truly nominal, not hundreds of dollars designed to function as economic gatekeeping. And finally, the sweeping sensitive place designations that states erected after Bruin, turning public buses, parking lots, libraries, Times Square sidewalks, and convenience stores into gun-free zones, were struck down as having no historical basis. Historically, sensitive places were specific. Limited venues, courthouses, legislative chambers, not entire cities. The attempt to convert whole states into de facto gun-free zones is over. Now, pull back from the legal theory for a moment and think about what this means for two specific Americans, two real people whose lives just changed because of this ruling in completely opposite ways. And both of those changes deserve to be taken seriously. Think about a single mother working the night shift in Los Angeles. She doesn't live in a safe neighborhood. She doesn't have a car. She takes public transit home at 2 in the morning. And she has asked herself every single night whether she would be able to protect herself if the worst happened under the laws that existed last week. If she was carrying a firearm on that bus, she was likely committing a felony. The state of California had designated public transit as a sensitive place where carry was banned. She had no meaningful ability to exercise her constitutional right during the hours when she was most vulnerable in the most dangerous stretches of her commute. That law is now unenforceable. Whether you support broad gun rights or not, you have to grapple with what it means to tell that woman that her safety is constitutionally permitted to be compromised. Because lawmakers decided that a public bus is a sensitive place. Now, think about a police officer in rural Illinois pulling over a driver for a routine traffic stop. The driver hands over a permit from another state, a state that, under the new ruling, can no longer impose training requirements or subjective approval standards. The officer looks at that permit and realizes he has no way of knowing whether the person in that car has ever held a firearm safely in their life. That is the new reality of constitutional carry, and pretending it doesn't come with complexity would be dishonest. Both of these realities are true simultaneously. The court did not resolve that tension, it intensified it. The legal mechanism that made this ruling possible is rooted in United States versus Rahimi, decided in 2024, a case that, on its surface, seemed like a win for gun control because it upheld the federal law banning firearms for people under domestic violence restraining orders. But what Rahimi actually did was far more consequential for the future of gun law than the specific outcome suggested. Before Rahimi, some lower courts were striking down virtually every gun restriction because they demanded a near-perfect historical twin, a law from 1791 that looked essentially identical to the modern law being challenged. Rahimi said, no, you only need a historical analog, not an exact twin. But then the court drew the line. The government must prove that the law is relevantly similar to historical traditions in both burden and justification. In this new ruling, the court took that Rahimi framework and surgically applied it to every licensing scheme under challenge. The government argued that 18th century surety bond requirements for dangerous persons justified modern permitting fees. The court rejected that comparison as constitutionally inadequate. The government argued that militia training requirements from the colonial era justified mandatory modern training courses. The court rejected that too, pointing out that militia training applied universally to members of the militia, while modern training requirements target individual civilians trying to exercise a right that the Heller decision explicitly identified as individual. Each historical argument the government offered was weighed, examined, and found insufficient. This wasn't an activist court making law. This was a court applying the methodology it established 2 years ago with brutal consistency. The government had 2 years to build its historical case. It failed. Nobody is talking about the dissent with enough seriousness, and that is a failure of journalism. When a ruling is 9-0, it is easy to gloss over the separate opinions as irrelevant minority views. But the separate opinions filed in this case are not losers complaining about the score. They are roadmaps for what is coming next, roadmaps for what the majority left unresolved. And in at least one case, a harrowing acknowledgement from inside the court that the system it is operating under may already be broken. Justice Thomas, in his characteristic fashion, wrote that the majority did not go far enough. He wanted to go after the background check system itself, the fundamental infrastructure of federal firearms regulation. That view did not carry the day, but it is on the record, and it signals where the most aggressive interpretation of Second Amendment rights is heading. Justice Alito warned about the chaos that comes when states are simply allowed to rename their restrictions, calling a permitting requirement something else, redesigning the same gatekeeping mechanism in new legal, close, and daring the courts to catch up. He saw the cat-and-mouse dynamic clearly, but it was Justice Ketanji Brown Jackson's concurrence that stopped me cold, because she said out loud what most justices are careful to leave unspoken. She admitted in writing, in a Supreme Court opinion, that the Bruin test has resulted in a 455% increase in Second Amendment challenges flooding the federal court system. 455%. She described the test as, in her words, unworkable. She essentially handed a warning to every lower court judge in the country. Good luck. The system is producing so much litigation, so much inconsistency, so many contradictory outcomes that the framework itself may be collapsing under its own weight. That is the quiet catastrophe that the victory lap coverage is completely missing. This ruling didn't end the Second Amendment wars. It guaranteed at least a generation more of them, and it guaranteed they would be fought in every courthouse in the country simultaneously. The philosophical shift this ruling represents is profound and deserves to be stated plainly. For 40 years, the gun control movement operated under the public health model. It treated firearms the way public health officials treat cigarettes, as a dangerous product that could be regulated toward near invisibility through licensing, taxation, advertising restrictions, and bureaucratic barriers. The court has now ruled that the public health model is constitutionally incompatible with the Second Amendment. The right to bear arms is a civil right. It sits in the same constitutional tier as the right to speak, the right to worship, the right to vote. You cannot tax the right to speak. You cannot require a license to vote. You cannot, the court has now firmly established, require a permit to carry a weapon. That is not a conservative talking point. That is, the current constitutional law of the United States. Because the states are losing their primary legal tools, the battle is actively migrating downward to the local level, and what is coming at the city and county level may ultimately be more effective at restricting carry than anything to the states were doing before. San Francisco may not be able to legally ban your firearm, but watch for ordinances that hold any private business liable for shootings that occur on premises where carry laws were permitted. That legal maneuver effectively outsources the gun-free zone to the private sector through market pressure. Businesses that allow carry take on legal risk. Businesses that ban carry are protected. The sensitive place disappears from the criminal code and reappears in the civil liability ecosystem. It accomplishes the same restriction through a mechanism the court hasn't addressed yet. Expect safe storage laws to escalate dramatically, not as gentle recommendations, but as actively enforced mandates with significant financial penalties. The state cannot stop you from buying the gun, but it may be able to fine you $1,000 a day if that gun isn't secured in a specific manner in your own home. Watch for red flag laws, also called extreme risk protection orders, to be used far more aggressively and to expand their definitions of who qualifies as a dangerous person. The Rahimi decision gave the government a constitutional blueprint for disarming people deemed a threat before they commit a crime. States are going to stretch that blueprint as wide as it will. If you were involuntarily committed for a mental health evaluation 20 years ago, you may find yourself on a list. If you have a history of public altercations, you may find yourself on a list. The removal of permitting requirements as a barrier to entry is the headline. The expansion of who counts as a prohibited person is the real story underneath. There is also a case waiting in the wings that nobody outside of Second Amendment legal circles is watching closely enough. Wofford versus Lopez. Hawaii has attempted to ban carry on private property without express permission from the property owner, effectively turning every store, parking lot, park, and business in the state into a presumptive gun-free zone, unless the owner posts a specific welcome sign. The Ninth Circuit upheld that ban. After this 9-0 ruling, the Supreme Court is almost certainly going to take that case, and the outcome is equally certain. If the court has ruled that you don't need a permit from the state government to exercise your right, the state cannot construct a system where you need a sign from a landlord to walk through a shopping mall. That case is the next domino. Count on it. Let me be clear about what is established fact, what is active legal reality, and what is media noise, because you deserve the separation. The requirement for may issue permits is gone. The requirement for mandatory training classes as a prerequisite for obtaining the right to carry is gone. Excessive application fees are gone. Blanket sensitive place designations covering ordinary public spaces are gone. Those are not predictions. Those are the confirmed legal outcomes of this ruling as it stands today. What remains genuinely uncertain is the empirical question that everyone is fighting about. Does this make communities safer or more dangerous? Criminologists are legitimately split on this question. There are peer-reviewed studies suggesting that right-to-carry laws correlate with reductions in violent crime because armed potential victims deter criminal behavior. There are equally rigorous studies showing correlations with increases in aggravated assaults, because more guns in more places means more lethal outcomes when ordinary conflicts escalate. The honest answer is that we do not have the data specific to this ruling yet. We will not have it for years. Anyone telling you with certainty that crime will plummet or that blood will run in the streets is lying to you, either to sell you something or to harvest your outrage for engagement. The truth will emerge slowly, unevenly, and will vary dramatically by geography, by density, by local law enforcement culture, and by a dozen other variables that no pundit on television is accounting for right now. What is not uncertain is the political and legal reality of the moment. Every state in the country is technically out of compliance with this ruling right now. The attorneys general of restrictive states have a binary choice: rewrite their laws to meet the new constitutional standard within weeks, or fight injunction after injunction in federal courts for the next 5 to 10 years against a 9-0 backdrop. Given the margin, most of them will choose to rewrite. Watch for emergency legislative sessions called in New York, California, and Illinois in the coming days. Watch for new laws that appear to comply on the surface while embedding the same gatekeeping functions in new legal dress. The cat and mouse game Justice Alito warned about is already beginning. The federal constitutional concealed carry reciprocity legislation that has been debated in Congress has effectively been overtaken by events. If no state can impose expensive training, subjective approval, or excessive fees on its own residents, the argument that every state must recognize every other state's permits becomes almost legally redundant. The constitutional principle that a fundamental right cannot be burdened by which side of a state line you happen to be standing on is now firmly on the table in a way it never was before. Here's the philosophical divide that this ruling forces every American to sit with, and it is not a comfortable sit no matter where you stand. The dissenting justices and, yes, there were 3 separate opinions written, even though the vote was unanimous, on the narrow question warned that the majority is applying an 18th century framework to a 21st century crisis. They are not wrong that the America of 1791 had 3 million people, single-shot muskets, and vast wilderness. They are not wrong that the constitutional tradition being cited was written in a world where the lethality of a weapon and the speed of its delivery were incomparably limited compared to today. That argument deserves to be taken seriously. The majority's response, that rights are not subject to cost-benefit analysis, that the government cannot erode constitutional guarantees simply because technology has made the exercise of a right more dangerous, that also deserves to be taken seriously. This is not a debate between people who care about the Constitution and people who don't. It is a debate between 2 genuinely held and genuinely compelling visions of what constitutional fidelity requires in a changed world. Where you land on that debate says something real about your values and your vision of what America is supposed to be. What I know for certain is this: the panic in 19 state capitals is not theater. It is the sound of a century of legal architecture coming down for the first time in American history. The right to bear arms, meaning the right to carry a firearm outside your home, on a public street, into your daily life, is on constitutional equal footing with the right to keep one inside your home. The Supreme Court has spoken unanimously. The lower courts will follow, the laws will be rewritten, the battles will move to new terrain, and somewhere in the middle of all of this, ordinary Americans, the single mother on the late-night bus, the police officer at the traffic stop, the store owner, the teacher, the parent, are going to have to live in a country that just changed in ways that the headlines aren't fully capturing yet. My job is to make sure you understand what actually changed, what is coming next, and what the people in power are hoping you won't notice buried in the legal details. That job doesn't stop here. If you want to be in this with me, if you want the analysis that goes past the headline and into the machinery of what is actually happening to your rights, your safety, and your country, then subscribe right now. Leave your reaction in the comments below and share this with somebody who's only getting half the story from somewhere else. The Second Amendment wars are not over. They just entered a new and more complicated phase, and you deserve to understand every move before it's made.